Hi everybody, as promised, here is your AJ56 final exam review. A couple of things I want to go over, give you a little briefing before we start. First of all, the final is going to have approximately 55 questions on it. They'll all be true, false, and multiple choice questions. This review will be conducted by chapter, so you can go back and study up on anything you need to study. But understand that the final questions may be presented in a different order than what you see here in the review. The final exam is an open book, open notes exam, so make sure you take lots of notes during this review, and also know that this review video will not be available or viewable once the final is published and available to take in Canvas on Wednesday. So let's get started, and good luck on the final. Okay, let's start with Chapter 1, starting with the term evidence. The question is, the term evidence refers to all physical objects admitted in trial, but not to testimony, and that is false. Evidence includes testimony. Number 2, the prosecution has the burden of proving the defendant's guilt beyond a reasonable doubt. That is true. That's the basic premise for the prosecution. Let's take a look at a multiple choice. Number 3, in a criminal trial in the United States, the defense has the burden of persuasion. And this means the defense can try to persuade the jury that the prosecution has not established the defendant's guilt. And that is the correct answer. The defense does not have to prove anything else. They just have to persuade the jury that the DA or the prosecution did not do their job. Number 4, in a jury trial, who is the trier of the law? The answer to that is the judge. The jury is the trier of facts, and the judge is the trier of the law. Let's move to Chapter 2. The sole authority of the United States Supreme Court is to rule on constitutional issues. That is false. The U.S. Supreme Court does many other things. Number 6, if the plaintiff in a civil case establishes the case by a preponderance of the evidence, that means more than 50%, so 51 to 49, he or she will win the case, and that is true. That's a civil case. Number 7, in a criminal case, the judge can set aside the verdict if the jury voted to convict, but not if they voted to acquit. Number 8, the reporter's transcript, that is the court reporter, is a verbatim record of what is said at the trial court, and that is true. Number 9, proof beyond a reasonable doubt is required by due process in all criminal trials. Number 10, which of the following is a valid reason for a judge to set aside a verdict? The judge made erroneous rulings on the admission of prosecution evidence at the trial. Material evidence introduced by the prosecution at trial was false. Newly discovered evidence casts serious doubt on the defendant's guilt, or all of the above. The answer is D, all of the above. Police officers have qualified immunity from lawsuits under the Civil Rights Act of 1871 for all actions done in the line of duty, only for actions mandated by state law, for all actions done in good faith, or they do not have qualified immunity. The answer to that is C. If they're acting in good faith and within department guidelines and their actions are reasonable, which means they follow the standard of care, then they have qualified immunity from a civil lawsuit. Let's move to Chapter 3. During discovery, the prosecution has a duty to disclose evidence in its possession that tends to indicate the defendant is not guilty. And the answer is true. That's under Brady, the Brady rule, which means the prosecution has to turn that information over to the defense. Number 13, opening statements are not evidence in the trial. That is true. An opening statement is done by the DA talking to the jury about what they are going to try to prove. It is not considered a piece of evidence in and of itself. Rehabilitation is an attempt to support the credibility of a witness who is impeached, and that is true. If a witness gets impeached by the opposing attorney, then the first attorney can attempt to rehabilitate that person in the eyes of the jury. Number 15, which of the following is done at the preliminary hearing? This is kind of a trick question. The preliminary hearing. A, file a criminal complaint with the court. B, witnesses testify about the events that occurred while the crime was committed. C, the defendant enters a plea. Or D, all of the events occur at a preliminary hearing. The answer is B, witnesses testify about events that occurred. Remember, this is a preliminary hearing, not an arraignment. That's the tricky part here. Those other things happen at an arraignment. Number 16, the prosecutor's opening statement, A, is the first thing done at the trial. B, is the next thing after the jury is sworn in. C, it follows the defense's opening statement. Or D, it's only given if the case is tried without a jury. The answer to this is B. The prosecutor's opening statement is done right after the jury is sworn in. Number 17, during the prosecution's case in chief, A, the prosecutor conducts direct examination of all witnesses. The defense has the right to cross-examine all prosecution witnesses. The prosecution must establish guilt for each crime beyond a reasonable doubt, or all of these, and the answer is all of them. D. Number 18, which of the following can be used to impeach a witness during a trial? It's going to be all of these, which is prior inconsistent statements made by the witness, showing the witness is prejudiced, proof of witness's prior felony conviction, or all, and it is all. Moving to Chapter 4, relevant evidence includes any evidence that tends to prove or disprove a disputed fact in the case. That is true. Number 20, all relevant evidence is admissible. False. It is not. There are many reasons why evidence, even though it is relevant, may not be admissible as ruled by the judge. Number 21, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of misleading the jury. That is true. 22, direct evidence establishes a fact without an inference. That is true. It's direct evidence. Doesn't require inference. Circumstantial evidence relies on inferences to establish facts, and that is true also. If the attorneys stipulate to a fact, that means they agree to agree, no evidence will be introduced at trial about that fact. That is true. Sometimes that's strategic because the opposing attorney doesn't want all of the evidence to be shown to the jury, so they can circumvent that by saying, I'll just stipulate that this is true. Number 25, the judge may take judicial notice of any commonly known fact, like the sun came up yesterday at 6:28 p.m. The answer to that is true. Stuff like that. Something is at issue in a trial if it relates to, and I'll tell you it's, in this case, A, any disputed element of a crime that is charged. 27, testimonial evidence refers to statements made while testifying under oath, affidavits, depositions, or all of these. The answer is all of these are different forms of testimony, so it's D. Number 28, the federal rules of evidence mandate that a judge take judicial notice of A, facts that can be readily determined from a source whose accuracy is beyond dispute. So just like the sun came up at 628 or whatever I said, things that are just known to be true. Moving to Chapter 5. The jurors may consider the demeanor of a witness when assessing his or her credibility. That is true. If a witness is hostile toward one side or the other, the jury is allowed to consider that in terms of that person's credibility. Number 30, the prosecution may introduce evidence regarding special skills the defendant possesses if these skills are relevant to the way the crime was committed. I think the example I used was a safe cracker. This guy is known to have, he's a locksmith, and just so happens that somebody would have to have been a locksmith to have committed the crime. The answer to this one is true. That can be introduced if it's relevant. 31. Prior threats to commit a similar crime are never admissible at trial because they are unduly prejudicial. That's false. If somebody threatened to commit a similar crime and we have someone to testify about that, that's perfectly acceptable. 32. Testimony regarding the defendant's efforts to destroy evidence is admissible as circumstantial evidence of guilt. That is true. If you introduce that evidence, it's perfectly fine. 33. The jury may infer that the defendant is guilty if he or she attempted to flee the scene of the crime. That is also true. 34. The fact that the defendant failed to testify at trial cannot be used as circumstantial evidence against his or her guilt. That is true. Somebody can decide not to testify or refuse to testify and just sit there as a defendant, and we're not allowed to consider that in terms of whether or not they're guilty. The fact that they did not testify. 35. The defendant's character is not admissible in a criminal trial. That's false. We can bring in people to talk or to testify about the defendant's character. 36. The character traits of the victim are irrelevant at a criminal trial. Also false. Witnesses can be brought in to testify about the character of the victim. 37. When deciding whether circumstantial evidence should be admitted at trial, the judge considers, and it's going to be all of these, whether the evidence is relevant, whether introducing the evidence will take up too much time, whether the evidence will unduly prejudice the jurors, and of course D, all of the above. 38. In a jury trial, who determines if a witness is telling the truth? That's the job of the jury. The choices are judge, jury, prosecutor, and defense attorney. 39. The fact that the defendant has a graduate degree in software design is admissible in a case in which a hacker bypassed a company's security system and transferred money to a Swiss bank account. C, only if his degree establishes certain skill or technical knowledge that would have been necessary to commit the crime. Number 40, the fact that the defendant received $100,000 from a life insurance policy due to the death of the murder victim is admissible to show motive for the defendant to kill the victim. Again, there was something in it for the suspect in this case. So the answer is A. 41. At a trial, character is introduced by someone who is familiar with what people in the community say about the person in question. Kind of weird. It kind of reminds me of gossip, but that's where character testimony is allowed. 42. Evidence the victim has previously filed false police reports can be used to infer that the current reporting was also false. So that's C in this case. Moving to Chapter 6. An attorney is allowed to have an expert testify about the results from a scientific test only if the test has been approved by the state's Judicial Council. That's false. I've never heard that before. The Judicial Council really doesn't have anything to do with that. Bias or prejudice can be shown by all of the following: friendship, racism, having a financial interest in the outcome of the case, and in this case, all of those can be used to show bias or prejudice. 45. A witness who has been impeached by prior inconsistent statements can be rehabilitated by showing the statement was taken out of context, by showing an error in recording the statement, by showing that they have a reputation for telling the truth. So it's all of the above. Number 46. In which of the following situations is a lay witness allowed to give an opinion? The answer is all of these. Identification of someone's handwriting, who they know. Voice identification of someone they know. General statements about the speed of a car that most lay persons can judge fairly well. Number 47. In order to be allowed to testify as an expert witness, the person must have knowledge of the subject based on education and/or experience. Number 48. A jury is not allowed to infer a defendant is guilty based on the fact that he or she invoked a privilege, any privilege, in order to prevent testimony from being introduced at trial. That would be like the attorney-client privilege or the spousal privilege or the Fifth Amendment against self-incrimination. Any of those, if they invoke them, the jury's not allowed to consider that as evidence of guilt. Number 49. A confidential conversation loses its status as a privileged conversation if the holder of the privilege voluntarily discloses the content of that conversation to someone who is not covered by the privilege. I know that in the module we gave an example of that. Number 50. Any evidence, such as the murder weapon, that the defendant turns over to their defense attorney is privileged, and that is false. The defense attorney has an ethical obligation to turn something like that over to the police or to the prosecution. Number 51. The privilege not to testify against a spouse can be used only if the parties are married at the time the spouse is called to the witness stand, and that is true. 52. Nearly all states give newspaper reporters a statutory right to refuse to testify about the source of information that he or she collected for a story which was not published. It's really whether or not it was published, but we're talking about refusing to give up their sources. Nearly all states provide that, and as you recall, the U.S. Supreme Court did not recognize that reporters had that right, but most states have allowed that. 53. If a defendant invokes the privilege against self-incrimination, that's plead the fifth, and refuses to testify at trial, what should the prosecutor do? In this case, there are some examples like argue to the jury that they can infer guilt? No. Ask the judge to cite the defendant? No. Report the defense attorney to the bar? No. They should make no comment on the defendant's invocation of their rights. That's D. Number 54. Statements made during the initial conference with an attorney are actually covered by the attorney-client privilege. That's D in this case. Whether or not the defendant ends up hiring that attorney, those initial meetings and conferences are still covered by attorney-client privilege. Number 55. The privilege for confidential communications between a husband and wife cannot be invoked if the husband has been charged with any of these: domestic violence against the wife, child abuse against his stepchildren, bigamy. It's all of the above. 57. The physician-patient privilege applies if the patient consults the doctor for the purpose of diagnosis, treatment, or obtaining a second opinion. All of the above are covered by the physician-patient privilege. And finally, when the defense files a motion demanding to see the personnel file of the arresting officer, the judge will do one of the following: review the personnel file in camera, that means in their chambers, before announcing a decision, order the grand jury to investigate the allegations, send the case up to the appellate court, or order the internal affairs unit of the police department to provide the reports to the defense. The answer is A, The judge reviews it in camera and then makes their decision. Well, that concludes our review for the final. Make sure you study. Good luck, and we'll see you online.